the previous speakers this morning have laid a solid foundation on which I'm going to build for this presentation. So when I talk about striking a balance, I'm really drawing from what has already been said. What is TK? Why does it need to be protected? What are the different theories which we are contending with here? And of course, when we talk about striking a balance, we need to remember that the whole essence, the whole purpose of intellectual property is really to try and make knowledge accessible, even TK. Without bringing IP into the picture, some of the ideas would not be accessible to many people. So it's the whole idea of making knowledge accessible and also in giving people entitlements. So that's my point of departure. And this is the overview that I'm going to, I think we've got too much light. This is the overview that I'm going to rely on. Just a very brief introduction. A very brief introduction to highlight on what lies at the crossroads, because the theme for our panel is to try and see what's happening at the crossroads. So what lies at the crossroads in terms of IP protection, traditional knowledge, and access to knowledge. Then I'll move on to consider whether the progressive appropriation of TK through the IP system is really trying to preserve cultural knowledge and also traditional knowledge. And then, of course, that will be very brief. I'll move on to the issues which are involved in trying to strike that balance of protecting intellectual property rights, TK, while at the same time ensuring access to knowledge to those who need it desperately to use it. And finally, the most substantive part is for me to consider the means which are currently being used, which have already been mentioned by some of the previous presenters. So I'll just pick a few of the ideas and zero in on that to give an assessment of whether there really is a way of striking a balance or not. So that will form my concluding remarks. And when we think of what lies at the crossroads, it's quite evident from what has been said already. We do have a dichotomy when you think of the IP system. There is a dichotomy between what you're protecting in terms of the product and the knowledge on which you're basing that product which is being protected. And we're going to see shortly how that can be problematic when dealing with TK and trying to strike the necessary balance. And secondly, there's this problem of cross-cultural problem where people who hold IP or people who enjoy rights in traditional knowledge interact with both the regular IP system, the conventional IP system, and other systems which they have in their communities. So it's not that there's nothing at all in these communities that has been used previously or it's being used to protect and preserve traditional knowledge. So there's that sort of tension. They have to confront those two different systems when they're dealing with these particular rights. Well, so that is what really lies at the crossroad, this cross-cultural problem where there are different systems, and one cannot say that these systems in the communities are not really, they might be diverse, but they're structured in a particular way. People know who owns what, and how people should deal with those rights and how they should be protected. And one interesting point to mention at this stage when you're talking about the cross-cultural problem is this. The communities have their interests which they want to be recognized, and they want those interests to be protected. And when we use the regular IP system to protect those rights, then we hit a snag in the sense that we are talking of economic rights and also moral rights. I'll highlight that shortly, because when you consider both economic and moral rights at the same time, it becomes rather difficult to protect all these aspects at the same time. But definitely something can be done about it. So let's consider the whole idea of progressive appropriation and see whether the interests of the TK holders are really being protected. The first concern that arises when we look at the progressive appropriation is this. You cannot really say that the conventional IP system really preserves culture in the process of protecting traditional knowledge. And that is because of the reason that are given before. You have both moral rights that these people have, and the IP system focuses too much, or rather exclusively, on economic rights. While at the same time, the moral rights or the human rights at stake may not really be given the adequate attention that they deserve. So that's one of the problems when we look at the progressive appropriation of TK through the IP system. And obviously, the system is rather inaccessible to most of the TK holders. If you think of the document-intensive process of getting this right through to the communities, it's rather inaccessible unless they have a properly organized system. And even if they have that proper organization, of course, you know how the communities operate. I'm going to highlight some of the concerns shortly when we deal with the conventional IP system, which sometimes does not really favor the TK holders. So this is briefly my outline when I go into the details of protecting TK and trying to strike a balance. Obviously, the main or the conventional IP system has some shortcomings, and that's why we are not able to strike a balance at the moment. I was consoled to hear that WIPO is trying to do something about it by digging into this huge bag of IP rights and pulling out concepts to see how this can be reconciled with the needs of the TK holders. So that is really encouraging, and as I go through this list, at least I have that very much in mind, that something is being done about it. So let's see, the shortcomings that I'm going to highlight are basically put forward by Dutfield. I had an opportunity to work with him on a different project related to protecting traditional knowledge of the San community, and also some traditional healers in Nigeria, and how benefit sharing can be fostered in these communities. So that was my first meeting with Graham. And what Graham says, sorry to call him on first name basis because of that kind of working relationship. First of all, when we look at copyright, when we make an attempt to use copyright law to protect traditional knowledge, the whole notion of authorship can be problematic. I'm otherwise aware that most people or most systems are trying to move away from that system, so it is possible to fit these communities right within the concept of authorship. So that can be problematic for this kind of communities. And secondly, there is a time limit that's fixed once these people take out rights in terms of copyrights. What they want is sort of perpetual protection, not a limited period. And if you think of the nature of traditional knowledge, it doesn't lend itself to that kind of approach where you say that after 70 years or 50 years, this is going to fall into public domain, which is a different debate altogether, forthcoming in panel 3, about what is within public domain in the context of traditional knowledge. And of course, the works need to be fixed. Some of the traditional knowledge, as we've seen in the previous presentations, do not really have a fixed form. So that formal requirement in terms of copyright may be problematic, and definitely qualified person within the law of copyright can also be practically challenging. If you're talking of a whole nation, at least we just heard that sometimes you can have a nation being entitled to some rights. But when you're talking about different groups, I was talking to an Iranian gentleman who is doing his doctorate at the World Trade Institute on protection of Iranian carpets. And I had a very interesting discussion where he told me that the same knowledge is used in India, in Pakistan, in Iran. Now, if you want to talk about qualified person in the concept of copyright, where do you fit these people in Pakistan, India, Iran, etc.? So I found that really interesting. So we can't just have a geographical boundary, which is rather artificial, and think that, well, these people are in Iran, so we can allocate these rights. How about their counterparts in Pakistan, in India, who have the same practices and lay claim to the same rights? In terms of patents, the same shortcomings can be applied, the concept of invention, an inventor. Again, the communities may find obstacles when they have to present their claim for patents. At the same time, we have the huge costs that they have to encounter when they apply for the rights, and finally, duration issue again. They don't just want limited protection, it has to go on for a while. And all the other types of rights in this other column as well, we can advance the same argument that there are shortcomings when we try to fit traditional knowledge within that framework. This is not to say that the system is not useful. It is very useful. It just has gaps that need to be filled in. And my idea is to assess whether we are striking a balance or not. And what are the challenges when it comes to making the attempt? The very first challenge that I've mentioned is that there's no guarantee of preserving or safeguarding traditional knowledge when you use this system. And this, what we have here is a fluid chair, very airy and very fluid, which challenges the conventions of a chair. And what I have in mind in using that graphic is this. Are we, in other words, using that in terms of protecting TK, given the shortcomings that we've noted? Are we, in other words, presenting these people with an airy and fluid chair to sit on in terms of protecting their rights? The first challenge really lies in the fact that we have that dichotomy, which I already mentioned, and there's that need to respect the intellectual property rights while at the same time respecting moral and material rights that these people have in that knowledge. And that's where the challenge lies in that particular attempt. And this system is also rather narrow. We've seen how there's a time limit, for instance. You have to identify a specific component. Well, TK holders don't want to pigeonhole these entitlements. So that's what they find rather challenging. If you want to come and tell them about copyright, patents, GIs, etc., it's rather mind-boggling. They just want to see their entitlements encompassing economic and also moral rights being acknowledged and protected. And even protection may be a bit of a challenge to them. Why? Why protect it? Somebody said earlier, do we really need to protect these rights? Do we need to commercialize them? Some communities might have issues with that, especially if they're underlying religious or cultural practices which they think are not compatible with commercialization. So that's where the second challenge comes. If you're going to tell them we'll protect this component, but this other one is not protectable. So that's where the problem lies. Then thirdly is the whole need to control the manner in which the knowledge is used. Definitely, the intellectual property system is not going to allow TK holders to lay control or excess control over the manner in which people use those rights. I mentioned at the very beginning of this presentation that the whole essence of IP is to make knowledge accessible, make other people use it. And here we are, having people that want to exercise control over how this knowledge is used. So that is rather problematic, and those are some of the weaknesses that make striking a balance a little bit challenging when dealing with these communities. At the same time, we have to remember that we have public-private rights, playing against each other. And some of the communities, I remember dealing with the San community, for instance. You have the San community in Namibia, in South Africa, in Botswana. In all these countries, there's the language issue. There's the geographical boundaries that are artificially dividing them or separating them. And if you want to allocate rights, who do you allocate these rights to? And they believe that it's the entire community that holds it. Yet they're under different government systems, different legal systems, probably, and we want to protect the knowledge that they all lay claim to. So these are some of the underlying challenges that we meet when dealing with TK. And then just to talk a little bit regarding access to knowledge-related challenges. For instance, if we want to encourage TK holders to document this knowledge so that it's easy for patent registration offices to search and slap somebody with the defense of prior art. We are not going to register this because it falls within prior art. it's not so easy to document everything. And also when people talk about public domain, this is rather amorphous. And there are many debates going on about what falls within public domain and how it should be handled. So that is very challenging. At the same time, we may say that the communities can document the knowledge, but still, I'm just winding up, but still, it's not really easy for them to document everything so that the patent system can lay that defense of prior art against the applicants. And also the issue of public domain, the interpretations which we have on the table are rather broad. So I won't go so much into that because we'll discuss again in panel 3. We've already seen the means that are currently being used. I think the other presenters went into details of the defensive, positive means of protecting TK. At the same time, elimination of erroneously granted patents. I just wanted to mention that this can be rather costly for the TK holders. So it's something that needs to be addressed. And also establishing databases, it has advantages, yes, that you can claim that information falls within prior art, but you are not able to document everything. That is really challenging. And you can document certain portions of the knowledge. The others that can be subject to, do I say taboo? You cannot document certain aspects, or they're very sensitive, and therefore it's not really capable of being documented and used in that particular sense. So what really lies at this crossroad, and what can we do to strike a balance? In my view, I do think that there's a gap that we need to mind. And that gap really exists because of the issues that I've mentioned. We remember the non-conventional chair that we saw, the weaknesses in the current system, and obviously that presents a number of gaps that need to be addressed. And that, I hope, is something that can be done by WIPO and other stakeholders who are trying to revisit the principles of IP and see how TK holders' interests, which are both economic and moral at the same time, can fit within that framework. And I think that is the only way of filling the gap, trying to incorporate the different components that sometimes IP does not recognize and doesn't really protect. And the traditional knowledge holders are really keen on these components being protected as well. So for now, I will leave the discussion here and revisit some of the points when I speak again under panel number 3. Thank you.